witness and that sort of thing. I wasn't suggesting we would do written argument.
All right. Well, this particular motion, for me, given the posture of the motion and what's been argued, I don't see it as a motion that's really ripe for a ruling at this time. I think the issue's been squarely put before the parties, which is a requirement of disclosure of this information in an adequate time frame to allow for a response or preparation for it for the trial's penalty phase if we get there. I see this again as kind of getting into the discovery issues of the case, which are governed by Criminal Rule 16. All I will say moving forward then is a few things. To the extent this information is within the possession of parties and relevant to these issues raised, it does need to be disclosed as soon as possible since trial is coming up as quickly as it is. I understand we've got a deadline date in the court's scheduling order for the pretrial conference, which is on February 27th. However, the court always looks at these things in fairness in terms of getting information so the parties can adequately have time to prepare for trial. It sounds like there's additional disclosures that are coming. We're not yet to the deadline. In terms of the specific request as it relates to Wellner, I do agree with Ms. Smith that that's premature for the court to consider at this point and make any ruling or not. That would essentially be kind of a motion ruling if I were to do that. So I will have the matter under advisement. Mr. Thomas, if you think you're running into a time crunch and the responses you get are inadequate, you're free to bring the motion another time, and I'd probably be able to hear that on an expedited basis. And the same would apply with the state with it'll be heard later here, but the argument that there's a pending motion to compel there haven't been adequate disclosures at this time also. The court will consider these ongoing discovery disputes, if they are disputes, at issue, and without making a specific ruling, just allow the parties to come back if you want to narrow down the scope of what exactly you think they have that hasn't been provided. I'll make rulings at that point and try to get those done so that the parties can adequately prepare those issues for trial. So the issue is under advisement and subject to further proceedings based on the parties moving forward. I would just ask you, of course, to cooperate as much as possible to exchange the information to avoid having additional hearings if possible, and we'll resolve those with a follow-up hearing if necessary. So that'll be the determination on that motion. I know maybe that was a little confusing, Mr. Thomas, but do you have any questions about the ruling or how I intend to move forward on that? Okay, thank you, Ms. Smith. Any questions?
No, Your Honor.
All right, the next motion that is scheduled to be heard today is the motion filed January 26th by the defense entitled Motion for Pre-Selection Instruction to Potential Jurors. The state filed a response on February 2nd. Who's going to be arguing that motion?
I will be arguing for the state, Judge.
And Ms. Smith. Mr. Thomas, if you'd like to present your argument now on that motion, you may.
Thank you, Your Honor. We did do a motion for pre-selection instructions for the potential jurors. We tried to just make it pretty brief and user-friendly. When the state responded, I really don't take much issue with what they said in their response, other than in paragraph 3 on page 1, they said that the language tendered by the defendant misstates the law in Idaho and fails to adequately outline the process. Jurors will have to follow the matter. I know when people say, hey, you got a bad haircut, no offense. Well, when they say no offense, and it doesn't really mean anything. So I'm just offended that they think that I'm writing things that are misstating the law, and and not outlining the process to the jurors. I believe that our response is, or our request for a jury instruction is user friendly, is easy to hear, and I believe that theirs is very rote and very cumbersome. A lot of things to go through there. I'm not sure that we need all that. And also in there, if there is any instruction, if the court does go with their version, which I'm fine with, other than the fact that when they say that Mr. and Ms. Daybell have been charged with murder and or conspiracy to commit murder, Ms. Daybell has also been charged with conspiracy to commit murder and grand theft. And I think that that is the charge, and we've argued about that. And I think that if that is something that that is going to be put in there, I think that it needs to be accurately reflected, unlike what the state has put in theirs. But other than that, I have no other argument.
All right, thank you, Mr. Thomas. Ms. Smith?
Your Honor, the state agrees with the defense that in order to speed up jury selection, some guidance given to them before the voir dire process on the issue, specifically the process that the jury must follow in this case, will help both parties in the court during voir dire. When people are questions about their opinion of possible punishment for murder and or murder of children, having them a framework helps people really think about their potential prejudice, their potential bias for both sides. And so I agree, the state agrees with the defense that some instruction must be given. The state really looked at Idaho instructions, having recognized that those have been accepted and upheld by the higher courts in Idaho, believe that in any instruction the court would give in this situation, because none currently exists in the Idaho pattern instructions that adequately cover the concerns of both parties. So to that extent, I agree with the defense that the court is going to have to come up with an instruction that addresses our concerns that is not yet adequately covered by existing pattern instructions. So the cleanest thing to do is to look at the existing instructions and build from there. Our concerns with the language tendered by the defense is, it didn't adequately cover multiple defendants. It didn't adequately cover multiple charges. It did not reflect that the process the jurors must follow in large respect. It didn't reflect the full range of punishment that will be available on this case, which candidly, leaving out the possibility that a life sentence, that the individual could receive a range of, 10 to life, should there not be an aggravating circumstance found, is something that I think jurors the defense would want to question about. That absolutely should be part of this process. It fails to adequately mirror the actual instructions that are already on the table. And so the state put together one. We did not remove completely the language we proposed to be struck, because we wanted everybody to be aware of what was there and what we were suggesting should be removed. And so we are asking you to do what the defense is asking you to do, but to use an instruction that is based on existing instructions, and specifically Idaho Criminal Jury Instruction 202, 001, the voir dire instruction, 108, 1702, 1703, and 1704. Thank you.
All right, thank you, Ms. Smith. Any further argument on that issue, Mr. Thomas?
No, Your Honor.
All right, the court has before it then the motion for pre-selection instructions. The court will grant the motion in that I do determine that it's necessary to provide certain pre-selection instructions to potential jurors. In terms of what exactly or precisely will the instructions be, that's something the court's working on with the input of counsel, including these pleadings and filings. The court will come up with a proposed instruction and in further proceedings, the parties will be permitted an opportunity to review those instructions before they're given to the jurors, and I would call on the record for hearing any objections or proposed amendments to those instructions. So the motion is granted in the limited extent of the request is granted that the instruction will be given. The instruction, however, specifically what would be the instructions is to be further determined at a subsequent hearings before we get started with the impaneling of the jury. Questions on that ruling, or? All right, Ms. Smith, any questions?
No, Judge.
Okay, thanks for your argument on that. The next matter we would call then is the state's motion to compel. This is a motion filed by the state on January 25th requesting certain discovery be compelled. There's been a response to the request for discovery, which was attached, filed by the defense on January 30th. So I don't know if that narrowed the scope of what the state still requests or resolved it, but at this point, who's going to be offering argument for the state on this matter?
I will, Your Honor. It will be very brief.
Okay, Mr. Wood, and who's arguing for the defense?
I will, Your Honor.
Okay, thank you, Mr. Archibald. Mr. Wood, if you could present argument this time in support of the state's motion to compel.
Thank you. And Your Honor, as you have correctly stated, the state did file a motion to compel on January 25th, and the defense did respond with discovery disclosure. The only thing the state would put on the record, and it's kind of been covered already today, is pursuant to Idaho Code 1925-15 subparen 6, Rule 16 does govern discovery for the penalty phase of a death penalty trial. And what the state doesn't have yet, and I think this, and certainly the defense still has time to provide this, so is just we are concerned there's no witnesses in mitigation other than their experts. The state does expect that by the witness cutoff date that any other witnesses to be used in mitigation would be provided. Having said that, Your Honor, the defense did provide their discovery request, and we're grateful for that.
All right, thank you, Mr. Wood. Mr. Archibald?
Yes, Your Honor. We do plan to submit witness lists for trial. The guilt phase, we have put the state on notice. We do not intend to call our witnesses. And many of our fact witnesses for the guilt phase are the same as the state's. But we identify any others that we will put those on our lists and supplement our response to discovery. We have also asked our experts for sentencing if she's convicted. We have asked them to prepare some reports for the state to review. The state has received all of the reports that we have received. Those were generally produced in our mental health records. So the state has everything that we have. The court has reviewed everything that we have in those mental health records. So we're not hiding anything. We do have some mitigation witnesses that we will disclose that. Our mitigation expert is currently and has been interviewing and getting those names ready so that we can disclose that. And as soon as we have those lists, we will supplement our response, and we will include it in our witness list that's due.
All right, thank you, Mr. Archibald. Mr. Wood, anything further?
No.
Okay, well, this is styled as a motion to compel based on the further disclosures that have been provided and the argument of counsel. The court at this time will deny without prejudice the motion to compel, denied without prejudice that if it's necessary to refile and there remains any outstanding discovery, including discovery that would be required under Idaho Code 1925-15 sub 6, then the parties can remotion for another hearing, if necessary, on an expedited basis to discuss additional disclosures that need to be provided. As I mentioned previously, I just encourage the parties to continue to work towards making all your proper disclosures in time for trial. Nothing's been missed on a deadline yet, so for those reasons, the motion's denied without prejudice. Any questions on that ruling, Mr. Wood?
No, thank you.
All right, Mr. Archibald, any questions? All right, at this time, that concludes the motions that were filed in this case 1624. We've got additional motions to be heard in the companion case 1623. We will take a recess at this point mid-morning to prepare for those upcoming motions.